Good morning, Mr. Nat King Cole ushers in Viewpoint, the program of personalities, politicians, and perspectives. We certainly have perspectives and personalities this morning. We'll leave the politics out of it, which is what they would like to do in their illustrious positions. However, we may have a comment or two and some guy that's running here and there. In any event, we're always try to start with a kudo here on Viewpoint. And this morning I'd like to single out the Marine Corps League down there in Logan County. I live, as I say, the home now, Christian Village. And the Marine Corps League has done a lot for us. The first thing that happened when I got out there, I went out to Walmart and prevailed upon the manager to give the Christian homes some flags. And I appreciated that very much. He got a flag for each duplex apartment, plus 3 20-foot poles. In any event, the Marine Corps League took care of making sure that those were properly installed. So, and they recently now, the reason it's come up again is Bill Dennis has been very active, and he came across a fellow up at the VA clinic in Peoria who refurbishes electric carts for people who need them. And as a result of that chance acquaintanceship, he's brought this fellow down here to Lincoln, to Christian Homes, and we're refurbishing some electric carts for people. So kudos to those folks. Now, let's get right serious. We have a long morning. You and I are in over our head, but that's okay. We'll swim through it. Mrs. Busby, why don't you introduce our guest this morning?
I would proudly do that. We have
semi-proudly anyway.
We have 3 justices from the Appellate Court here in Lincoln, America. That they're all hometown boys made good. Yes, they are. Justice Knecht, Justice Harris, and Justice Turner. And I always said that I only knew one Phi Beta Kappa from the U of I, and that was Kathy McCullough. You will remember Kathy.
Sure. John
T.'s wife. And now I know 2. I didn't know you had that honor.
I kind of looked into that. I don't know how that happened.
I'm not sure you looked into. However, Judy, standing in the shower this morning, I had a moment of probity, and I'll tell you about that later. And I was forced to come up with the idea that we ought to have a disclaimer this morning. So in the interest of being, the FCC doesn't tell me to do that, nor did Jim Ash. But I think we should disclaim that Judy really, well, we tried to do this through the back door, but we had a moment of trying to get money out of Jim Ash, and that didn't work very well, so we couldn't get the airfare for this other judge. But we really didn't have Judy's favorite judge up there, and I'll let you go with that.
Well, my total acquaintanceship with the court system, I'm afraid, is Judge Judy. And she's kind of almost like opinionated, you know?
Like almost, maybe.
Do you think that that's good for us as a public or not, to see that kind of thing? And then if we come face to face with the judicial system, we're thinking everybody's Judge Judy, and I dare say, thank you God, they're not.
Well,
so we don't really learn from those things, do we?
Let's.
I think not. No, we don't learn anything. If we understand that it is entertainment,
period,
we're fine. If we begin to think that somehow resembles a courtroom, that would be a mistake.
That would be.
Well, the real purpose of having these illustrious gentlemen, I mean this, gentlemen with us this morning, is I think it's pretty unique. Logan County is really quite unique in having 3 men on their appellate bench who have Logan County roots. Justice Knecht doesn't live here anymore. He lives up there in Bloomington Normal area. But Justice Turner is still with us, and Justice Harris is out there east of town about a mile and a half or 2. And I think it's quite unique for a county to have 3 gentlemen sitting on the appellate bench. So that was why we're not going to learn any law this morning. I'm not smart enough to ask all questions, and I wouldn't want to confuse Justice Turner. So
that's easily done.
So
Bill,
kinda-
you've got it down pat. Everybody picks on Turner, and you're jumping right on top of it, so thanks.
I've known since you were Gilbert Norvetta's little child, so I guess that we go back a long
God
way.
love him, yeah, thank you.
And I remember Jim, I call him the Bard of Hickey's. He got his summa cum laude graduate from John Hickey's pool arena on Chicago Street. And
Made all the better by the fact that your business was there on
That's
Chicago Street. in
door
those
and a half
days.
away. And so that's how I first knew Justice Knecht. So that goes back a long ways. And with Justice Harris, his daddy and I were in school 13 years together before we went to college. Now, I know you're doing the math, 12 and 8 and all that, 4. But 13 is the reason we have 13 is Tom and I his father and I went to kindergarten together. So we go back a long ways. So it's a great joy for me personally to have thought the idea that it'd be nice to have those three gentlemen aboard. So let's take the court system and define it. What is the appellate court? Gord, anybody should know what that is, but which one of you would like to define the appellate court? Justice Harris?
Well, I'll field that one then. Think of it, it's a three-level system in Illinois. There are 3 layers to the courts. There's the trial court, which is where the vast bulk of the legal work is done in the state. Then there's an intermediate appellate court, which is our court, and then there's the Supreme Court. And we joke, and we hear this joke as well, that we're the anonymous court because most folks know their local trial court judges. They're familiar with cases that come through the local court system. But then when cases are appealed, they tend to lose track of those. And then when the Illinois Supreme Court decides a case, that usually gets quite a bit of attention. But the intermediate court system is where most cases actually stop. And I'll explain that just for a moment. Every case that comes out of Logan County, let's say, the Logan County Courthouse, the losing party has the absolute right to appeal that case to our court. Now, what happens after the appeal is finished? Well, the losing party in the appellate court doesn't get an automatic right to appeal to the Supreme Court. They have to request permission of the Supreme Court to take the appeal to that court. And less than 5% of those requests are actually granted by the Supreme Court. So for all intents and purposes, the appellate court is where the case ends. It's the court of last resort. And so that's why I tell folks, it's why they should care about what happens in the appellate court, because it usually is the end of the line for a case.
But a person doesn't automatically be accepted at the appellate court, do they? If they appeal to the appellate court from the local court, it isn't necessarily accepted, right?
Well, if it's a final judgment that comes out of the trial court, they have the absolute right to appeal that decision to the appellate court.
And do you have the absolute right to say, no, you can't come here with your case?
No, we have to accept that appeal.
Is that right?
Yes. And to give you a sense of the volume of cases in Illinois, now these statistics, these are a little dated. They don't update them annually. But I think this is from 2015 now. In Illinois, in 2015, there were, I think, 2.7 million new cases filed in the trial court.
Million.
Yes. And of those 2.7 million cases in the same year, there were 7,500 cases appealed to the appellate court. So you see that there's a real winnowing down of the cases as you go from the trial court to the appellate court. And then, as I said before, for the Supreme Court, they only accept a handful of these appeals. So there aren't many cases, relatively speaking, that are decided in the appellate court and then subsequently in the Supreme Court.
And Judy, just to follow up on that, the 4th District is comprised of 30 counties. So anyone who wants to take an appeal from the trial court in any of those 30 counties appeals to our court, and we take all of those. By contrast, as Tom has pointed out, the Supreme Court takes only a few cases, maybe about 100 a year.
And
Now-
in terms of those 30 counties, that is from Quincy to Danville and Dwight down to the Mississippi River. If you think about that, where the Mississippi River curves south of Quincy. So it is a huge district.
Yes.
Larger than congressional districts, for example, and probably larger and is more populated than some small eastern states.
In the event that somebody files an appeal for the appellate court, about how long would the waiting period be with this many courts being involved?
On the caseload?
It depends also on the type of case. So if it's a case that involves child custody matters,
yeah.
the Supreme Court has mandated that that particular case be given priority, and we have to issue a decision within a confined period of time. It's an expedited appeal. Other cases, on average, I'm not sure what it is right now, maybe a year from start to finish.
A lot of it depends on how quickly the briefs are submitted to our court from the attorneys. And in some of the criminal cases, there has been a kind of a backlog because the Office of the State Appellate Defender has a hard time keeping up with the volume. So sometimes those cases can take 2 years or more. But once we get it in our court, once we're supplied with the briefs, we run them out pretty quickly.
You mentioned the appellate defender, Justice Turner.
Yes.
A person doesn't go with their trial attorney from the county to the appellate court with that attorney?
Well, they certainly can, but as you know, a lot of people are indigent and therefore are entitled to the public defender. And if they've had the public defender at the trial level, they're probably going to need the appellate public defender for the appeal. And even if they had private counsel at the trial level, then they may not be able to afford hiring an attorney for the appeal, and then they also would be entitled to the public defender.
And of course, you have to remember that there are a lot of civil cases,
Yes.
money judgment cases that are appealed to the court, and typically those people don't do it by themselves. They need a lawyer to do that, and they bear the cost of hiring a lawyer in the trial court, and they're likely to bear the cost of hiring a lawyer to appeal. Sometimes it's exactly the same lawyer, and sometimes they will hire an appellate specialist, somebody who practices law for the purpose of helping trial attorneys appeal their cases.
In that vein, we've heard of clients who will act as their own attorneys, in the old expression, as a fool for a client.
Yeah.
Did you ever have does anybody come before the appellate court and on their own, pleading their own cases and so forth, without benefit of
Yeah, it happens, Bill. Pro
pretty
se.
silly, isn't it?
Yeah. Well, it's hard enough for the attorneys to follow all the rules, or let alone trying to do it pro se by yourself. And so they're probably going to struggle with it. On occasion, you might see someone who comes in without the benefit of a lawyer and does an okay job. But for the most part, it's going to be a tough road for them to hoe. Yes.
If you've got a really badly infected tooth, you better have the dentist take care of it. And if you need an appendectomy, you ask the lawyer, or you ask the doctor to do it. If you got a case on appeal, and really a case in the trial court,
Surely.
you need someone that
know
is
what the
a
heck's going
professional.
on.
Makes perfect
Just
sense.
what I read, doing a little research, I didn't know. I thought we were in pretty deep water, so I thought I'd swim in shallow water a little bit. So I brought up the computer, of course. Illinois Judicial College, Justice Knecht. What is the Illinois Judicial College?
It's an effort by the Supreme Court and a committee of the Supreme Court to provide advanced training as well as intermediate training for people who are already judges. Now, there's also a thing called the new judge school. That may not be the exact name of it, but that's its purpose.
Actual training.
Once you're elected, you have the opportunity to go to classes during a particular period of the year and learn from more experienced judges as well as sometimes law professors. But we are heavily involved in continuing legal education. Lawyers are required to book a certain number of professional education hours per year. Judges are as well. So we go to seminars and special programs, many of them designed by the Illinois Judicial College or whatever that committee is called by the Supreme Court, to provide us advanced training and professional training. We have to keep up on the law, just like a doctor has to keep up on new medical treatments and techniques. For example, you need to take aspirin when you're of a certain age, and then a study comes out and says, no, you shouldn't take that aspirin unless you meet these criteria. It's the same thing in the legal system. We have to be aware of trends, new developments in science, changes in the law, and we are a well-educated judiciary in Illinois.
You know, it occurs to me, it should occur to anybody, that just sitting on a circuit bench wouldn't automatically qualify you to be an appellate judge. I mean, you have to have certain basics, obviously, but they need to be honed by going to someplace like the Illinois Judicial College.
Apparently, you all serve on different committees, though, within the judiciary, and I see that you, Judge Harris, are on the Judicial Security Committee. Is that the one who keeps the Hanyak with the gun from coming into the courtroom?
Well, the Supreme Court really is pretty creative in developing initiatives and things to look at and study. And in fact, that particular committee disbanded a while back because I think they had things figured out to the point where the Supreme Court was satisfied. So that, you're right, it was put together in order to study security measures within courthouses. But then when there was a certain level of uniformity that was reached, and apparently the Supreme Court determined that there was no longer a need to continue with that particular committee, it disbanded. But there are lots of committees, you're right about that, and judges serve on these. They might have an interest in that particular committee. For instance, I serve currently on the Access to Justice Commission, which is a commission that was started by the Supreme Court to study the provision of legal services for those that can't afford to hire attorneys and to help them navigate their way through the judicial system and to make it a little more user-friendly. And that's I think, a pretty important effort because, as I think Justice Turner was indicating earlier, there are a number of litigants that do attempt to go it on their own. And as Justice Knecht indicated, these are complex cases. And it really is a tough thing for a lot of these folks to actually find their way through the system. So I have made it a point of, in my service on that commission, to emphasize that access to the courtroom doesn't equate to access for justice. And just because someone can find their way into the courtroom and file a suit or file a responsive pleading doesn't mean that they're actually going to obtain justice. And this is where I say having the services of a lawyer really is of utmost importance for most of these people.
Now, take us to a case that, let's say Judy sued me. I wonder why you haven't in 44 years, but anyway. She lost on the circuit court, and she wanted to appeal that. And so her lawyer will put the necessary paperwork into it, and it's going to appear before appellate. Now, where does it, once they walk in through your courtroom, how does that work? Do you hear what her lawyer had to say?
Now, who won this case?
Yeah.
Bill, you or Judy?
He won.
Oh.
You might know.
Well, then Judy and her lawyer would file a notice of appeal,
Yes.
which would go to the 4th District Appellate Court clerk.
And what does it go from there? Now, do you hear everything in the courtroom? my understanding is that you get the testimony and the paperwork and all that, retire to your offices in your respective homes and study it, and then come back and get together.
We get the common law record, which is the record established at the trial court level, and then we get transcripts of all the hearings, and then each judge has those, and each judge will look at those. In some cases, will go to an oral argument, which is held in Springfield at our courthouse. Most cases, however, are decided between the judges, and we sit in panels of 3 based upon reading the record and the briefs.
So in our hypothetical case, we may not appear at all?
Well,
as litigants, we wouldn't, only our lawyer.
Your lawyer would appear for an oral argument if you request an oral argument. If you don't request an oral argument, the case would be decided without going to the court.
You just go through the
and you have to remember, we don't hear witnesses. There's no testimony. It's just arguments.
And you would be welcome to be there at the oral argument, but your attorney is the one who's appearing for you. And there's an extra cost, not for the court system, but for your lawyer to appear and make an oral argument. He's going to charge you more for that because he has to put extra time.
He's charge for his time.
Yeah.
But there's not an extra cost, court cost, is there?
No.
Yeah, but
not for
a filing fee, but not for the oral argument itself.
Yeah. So,
Bill,
yes,
Judy,
Justice.
I was just going to say, backing up for a moment, it'd be helpful to know that in our 4th District Appellate Court, there are 7 judges. And Justice Turner talked about a panel of 3 judges hearing a case, and that's how cases are decided, by a panel of 3 judges. They're selected at random by the clerk of the court, who is Carla Bender, another Lincolnite. We haven't mentioned. But the selection of the panel is done by random, and then the selection of the authoring judge is a selection that's done randomly as well. So the litigants going into a case, they don't know who will be judging their cases. They don't know who the authoring judge will be. And by authoring judge, I mean the individual judge who's selected to take the laboring oar to draft the proposed decision in that particular case. And then the other 2 panelists decide, based on what they read, whether or not they're going to agree with it, which is called a concurrence, or disagree, which would be a dissent. And if one of the panelists, both panelists concur, then it's a unanimous decision. If one of them disagrees, then there will be a dissent, and it'll be a 2-to-1 decision. If both panelists disagree with the authoring judge's proposal, then the authoring judge will likely become a dissent in that 2-to-1 decision. So I just, backing up, I wanted your listeners to know that these assignments are done by random, and you just don't know who it is that's going to be hearing a case, and we as judges, we don't know until we're notified by the clerk's office which cases we're going to be hearing.
Are you allowed to not accept a case that's assigned to you?
We we have certain ethical rules that require us to recuse ourselves if we have some conflict with that particular case. Perhaps there's some financial tie, a spouse that works for the company which is a party to the case, or we might have some other reason why we feel ethically bound to step away from that case. So in those situations, it's not just that we have the right to not participate in that case. We have an ethical obligation to not hear that case.
We have an obligation here too, justices. It's not ethical, it's legal, and I don't want to get into that if we don't give our sponsors a little time right now. So we'll doff our legal hats and go right to our sponsorships. All right, right back live in the studios here. We're having a good time with our justices, Justice Jim Knecht, Golden County boy, Justice John Turner, Golden County gentleman. Oh, well, I said boy and gentleman. I withdraws my comments.
You got it all right, Bill.
And my young friend, Justice Tom Harris, whose father and I were in school together many, many years. So it's a joy for me, particularly. Judy doesn't have the advantage of knowing these gentlemen as long as I've known them. She's just a kid and came to Lincoln.
Well, I went to Robbinsdale High School, so they weren't there.
We're talking about laws and so forth, and there's a phase of the law called expungement. Would Justice Knecht, would you like to tell us what that's about and why it's necessary, sir?
For
Let's say a criminal
right.
expungement.
A criminal expungement is sometimes available, and it's a remedy provided by the state legislature. I mean, it's a law, it's a statute for certain minor offenses, and sometimes people would argue a somewhat serious offense, for the offender to have his record expunged, meaning erased from the public record, though of course because of the cyber world, it's never fully erased, but it's erased in a formal sense. And the purpose for this is to permit someone to get on with their life. Employment is an issue for people who have a criminal record. And Illinois has been in the forefront of enacting expungement laws. Right now, the topical subject is the expungement of minor marijuana convictions. So if you appeal or if you apply for a job at State Farm, if your record has been expunged, you may legitimately say, I have no criminal convictions, which is very helpful to someone who had an arrest for a misadventure when they were 21 years old and they're going to work at State Farm when they're 31 or 32. I mean, that's in the past, and as long as it's not a crime of violence or a crime involving theft, financial issues, then the employer may not have the need to know those things or may not have the right to find those things in the public record. So it's stored. It would probably be the idea of restorative justice. This person has committed an offense. They've been punished for it. How long should that punishment last? That's a
Forever?
last, a rhetorical question. Now, if you're a sex offender, an armed robber, anything that's serious, it can't be expunged. But if it's a lesser offense, it's a way to give that person a leg up so that they can make good of their life.
So for society's sake, it's essentially good legislation to have an expungement process.
I think it is, because the expungement process is technical in the sense that there are hoops that have to be jumped through. There are requirements that have to be met, and it requires a court to review it to expunge the record.
The law, just like everything else in the world, evolves. And you mentioned marijuana. Now it's going to be decriminalized. It's going to be legal. And there are a lot of people who've been charged with that offense. Does this kind of situation happen very often where the law does change and that makes a whole category of people in a different category?
That's probably going to be up to the legislature and the governor. They could always change the law with regard to expungements, and that very well may include some of the marijuana offenses if the legislature decides to go that route. And they have done so over the last several years. And following up on what Justice Knecht said, it used to be you couldn't get an expungement if you got a conviction. Instead, you would be placed on something called court supervision. But they have expanded the expungement statute to cover more offenses and different kinds of offenses, and they very well may do that. When I say they, the General Assembly, and change the law in that regard.
And it's not a liberal approach. It's actually an approach for societal good. It benefits everybody.
The legalization of marijuana, that's going to create some court decisions down the road, I think. Judy thinks it's a gateway drug. This is pretty philosophical for me to get into, and I don't want to take our time now. So maybe I'll just bypass that marijuana question. But I did open up Pandora's box. We think it's a gateway drug to other problems. How do lawyers on the street feel about it? Do you have a feel for what the opinions are?
They all look at one another.
Clearly, many people believe that it is a gateway drug, and then many people believe that it isn't, and it isn't any different than alcohol. But
Yeah, but that's the rationale they're using. They say, well, of course it should be legalized because it's no worse than alcohol. But I think you can go up and down the streets and talk to any number of people who will tell you alcohol has ruined their life.
Definitely. And I think that you mentioned that we looked at each other. There are as many different opinions among lawyers and politicians and civic leaders as there are in this room right now. We have to look to other states, I think, for the practical effect. We can look at the state of Washington and we can look at the state of Colorado. And even then, we don't get the same information. It depends upon who's giving you the information. There are people that say in Colorado, oh, it's been terrible because there have been more traffic incidents, for example. And then you'll read another study that says there hasn't been any appreciable difference in traffic accidents as a result of someone being under the influence of marijuana. And the same thing in the state of Washington.
Well, speaking of such matters as societal matters such as marijuana, the gun laws. My opinion is that we have enough laws on the books now. We just need to enforce the laws. As practicing attorneys, how would you feel about enacting more strict gun laws? Justice Harris?
Well, so this dovetails with the last topic involving marijuana. As judges, we have personal opinions about these societal matters. Of course we do. What we can't do is we can't take our personal opinions into the courtroom with us. We have to leave them at the door. We're not legislators. We can only interpret the laws that are given to us by the state and do the best we can with that. So when it comes to your question in regards to gun laws, we've got gun laws on the books, and we regularly deal with matters relating to those gun laws. If the legislature sees fit to change those laws, we'll deal with the new laws. So really, we react to what the will of the people tells us in the form of the laws that are given to us. And we are basically given a case that has a well-defined set of laws that we have to interpret, and we deal with that case alone.
Even if you personally disapprove of what?
Absolutely.
That has anything to do with this. Has anything to do with how you personally feel. That's the
discipline we have to exercise.
Yeah.
That's the role of the judge. It's not just the appellate court. Every trial court judge that is hearing cases in the Logan County Courthouse, the McLean County Courthouse, everywhere in the state, they have to set aside their personal views and solely refine or confine their handling of the matter based on the laws as they exist.
A helpful thing to remember in regard to gun laws is that the Second Amendment is not absolute. By that I mean to say there are exceptions and restrictions on every single amendment in the Bill of Rights. That's logical that there would be restrictions. So we need moderation in this discussion. No one that has any realistic understanding of the process and the political system thinks the Second Amendment is going to be repealed. But the citizens should expect that the government has the power, both the state government and the federal government, to place restrictions upon that right that's thought to be absolute.
And just to follow up, never forget the importance of the United States Supreme Court and what they have told us they believe the Second Amendment says. And it was McDonald v. Chicago a few years ago basically said that the Second Amendment does apply to the states. And so therefore, our legislature, when they do draft new laws, they have to conform to what the United States Supreme Court has said.
Do legislators ever ask your opinions on a piece of legislation before they enact them, about the practicality of it, maybe?
Well, who in this group has had legislative experience? Maybe they could answer
Yes.
that.
Who is that person? In the General Assembly, there is, I forgot the committee, but there is a committee that reviews appellate court cases and Supreme Court cases, both statewide and at the United States Supreme Court level. And then that committee will come to legislators and say, here's what the courts have said about a specific piece of legislation. Do you think you should address it, or we suggest that you address it? And of course the lobbyists get in on that as well. Yeah. But as far as a state rep or a state senator contacting an appellate court judge and asking his or her perspective on a piece of legislation, I don't think that happens. At least I never observed it when I was in the General Assembly.
Maybe they could try it.
Well, he was known as Straight Arrow John, that's why.
Yeah.
Well,
John.
the legislature does keep up, not individual legislators, but through that committee on what the courts are doing.
Are there any unusual, or my word, quirky laws out there that you shake your head at and say, how in the heck are we going to deal with this? There must be lots of them because
I think
they do some funny things down there in that dome in Springfield.
Yeah, there are some quirky laws, and Justice Harris is going to give you a couple of examples, I think, here in a second.
You ready for that
Yes,
commercial break? No, it seems like every couple of weeks I run across something that in the form of a law that I never knew existed. It could be one that I agreed with, or one that I disagreed with on a personal level, but when you think about all of the laws that are out there and all of the different fact scenarios that might come into play, we're confronted with what seems like a case of first impression very frequently. And I never, before joining the court, I didn't think that could be, because there have been thousands of cases decided in Illinois, and yet here we are deciding what I'd consider to be cases of first impression. And it's partly because there are so many laws and changes in the laws being made every term.
Mm-hmm.
Now it's inevitable that you're in your respective offices studying a particular piece of legislation that's before you, or some trial work. You pick up the phone and call Justice Knecht, say, Jim, what do you think about this? You have to interact with one another. I mean, that's just, obviously, to me, it seemed that's the obvious way it would work.
Well, we do that.
You're going to make up your own minds.
There is communication between the judges on the court. We primarily do it by way of email, and it might seem like that's a slower way of handling things than what you suggested.
Hillary got in trouble with her emails.
Well, one benefit of doing it by way of email is that when you draft an email, you're a little more careful about what it is that you're putting down in terms of your thoughts, and you get it just right. And so it's a more considered and measured communication potentially than a phone call. Plus, as we talked about before, there are 3 judges on a panel, and so you'd like to have everybody's input that serves on the panel, and yet that's not real practical in terms of putting together a phone call with the three judges. Now, we do have the three judges talking in person after oral argument down in Springfield. After the case is heard, we go to a room and we deliberate and talk about the case. And to me, that's probably the most fun I have in a case, is hearing the thoughts and opinions of my colleagues who have just heard that case as well. And it's really where you get the fine points of the case honed in.
And that's part of your learning curve, too.
Sure. And we
Individually.
mentioned the internet or emails. We have an intranet system, so we have a secure means to communicate with one another. We're not worried about our emails being hacked. We leave that to the administrative office of the Illinois courts and judicial management system to provide sufficient security, and we have firewalls galore that give us confidence that our emails are secure and confidential.
But
Now,
just imagine before the advent of all this technology, how impossible it would be to keep everything right up to date, because it has to be written and then it would have to be mailed to, and oh my.
Well, when I started on the court, we used carrier pigeons.
Did you? That was fun.
Out of the back of John Hickey's pool hall. The retention system. We all know it shall so be retained. Is that the way it works on the appellate bench as well? And it comes up how often? The regular 4 years?
No, our years are 10. Our terms are 10 years. And so once you're elected, after 10 years, if you choose to stay on the court, you can run for retention. No one is on the ballot against you, but you have to get 60% of the votes cast in your race to be retained to the appellate court.
Well, you won't have to work on me. I'll be out of here before your term comes up.
And Justice Knecht, I think I've run for retention twice, and you've got at least
Probably
three.
3 times.
Yeah.
I want to re-emphasize again, and I'm not trying to stroke these gentlemen. I'll never have any litigation appear before any court, I hope, in any event. We are lucky here, our listeners. By the way, we have kind of hoarded the microphone, and we haven't given our listeners, both of you out there, a chance to call in. You might have a comment. Be nice now. These are special gentlemen. 648-5510. If you have any questions, the Justices Knecht and Justice Turner and Justice Harris would be very happy to field your questions. 648-5510. Mrs. Busby?
Yes.
You were champing at the bit to ask a question, and I can't tell you what it was.
I was, and I got all interested in what they were saying, and it just kind of disappeared.
Well, to pick up on what you said, Bill, about the tradition of Logan County, we'd be remiss if we didn't mention that Leland Simpkins,
Yes.
also of this county, served on the 4th District
Yes, he
Appellate
did,
Courts, as well as the senior member of our court before his retirement and death, John McCullough. So we have a long tradition in Logan County of providing legal luminaries to the
Yes.
4th
Well,
District
and I
Appellate
think you used the word luminaries exactly correctly.
I chose it purposely.
It is unique to have 3 of the 7 judges on the appellate court coming from Logan County.
Yeah.
As we've talked about earlier, the district does include 30 counties, and big counties like Champaign and
Sure.
McLean
That's
County.
almost a third of 102 counties. So we have how many districts, gentlemen?
There are
5 appellate districts.
5?
Cook County is its own district. It's the first
That's appropriate.
district.
Cook County should be its own in most everything up there.
And then the second district is to the west of Cook County. It consists, I think, of 13 counties. Maybe off on that. And then the numbers go down. The 5th district is the lower third of the state. We're pretty much the central third of the state in the 4th district. And Justice Knecht described it. Goes from east to west in terms of Missouri to Indiana.
Do you ever have to go to Chicago as a bench? Boy, that's a lucky thing.
If you're on the workers' comp court, you do go to Chicago 3 or 4 times a year. Is that right, Justice Harris?
Yes, we both served, Justice Turner and I both served on that division of the court for a period of time, and that's the only obligation to sit on a court in Chicago.
Go ahead, Judy.
How often
Sorry
do you
about
have to travel like that? Have you all been involved in going to Chicago to sit with them?
I was on the workers' comp court for a little bit less than a year, and then Justice Harris came on the court and replaced me there. And I think during that year I went to Chicago 4 times, but generally speaking, it's 4 to 5 times, maybe a year if you're on the workers' comp court. And then the other times that the workers' comp court sits for argument, they sit in Springfield, and it's about half the time in Cook County and half the time in Sangamon County.
It's a good point, though, to make here, in that the Workers' Compensation Division is the only area of specialization within the appellate court. It only hears workers' compensation cases. Other than that, though, the appellate court, our 4th District Appellate Court, hears every type of case out there. We're general practitioners, just like in medicine, the family practitioner sees all types of patients. The appellate court hears all kinds of cases, criminal, family, money lawsuits. In addition, the 4th District has Sangamon County within its boundaries, and all of the administrative agencies, the state agencies that are headquartered in Springfield, their decisions are appealed to our court. So we hear a wide variety of cases.
Do they try to break these down so that each district has relatively the same kind of population, the same number of population?
In theory.
In theory.
Yes. It's not, though, your traditional one person, one vote breakdown as far as how many people live in the 4th District versus the 5th District, 2nd or 3rd District. And then in Cook County, they have, I think it's 5 districts. Is that right?
Divisions.
Just 5 divisions within the Cook County. And when I was in the General Assembly, we actually reapportioned it to make it one person, one vote in Cook County. However, the other party said we were gerrymandering, and they wanted to make sure that all the judges would be Democrats, and so that we couldn't reapportion it so that a Republican could get in. And the legislation passed because the Republicans were in control, but the Supreme Court said unconstitutional.
Forget that, yeah.
Well, you always have that to deal with, and they're the final appeal, aren't they?
Well, Judith
They
Kay,
have the final say, yes. We
Yes. We
follow
have
what
been
they
so
say, whether
engrossed.
we like it or not.
You're right.
we've been so engrossed, Judith Kay. We've done something that we've never done in all the years we've been up here on Viewpoint. We've run out of time by about 5-6 minutes. Gentlemen, we appreciate your sharing your time and, more importantly, your expertise. It's been a real joy for me personally because of my affiliation with all of you for over a long period of years. You know, when you get to be 96 almost, you get to be long in the tooth and can forget a lot of things. So, Jim Knecht, the Bard of Sangamon Street and Hickey's Pool Hall, John Turner, the farm boy from a mile or 2 away.
May I say it's great to be back in Eminence Township.
Yes, you may. We'll give you that time. We're already over. Tom Harris, thank you very much for being with us, young fan. Very special pride for me. Thank you very, very much.
Thank you, Bill and Judy.
We try to close Viewpoint with the usual. Be the reason somebody smiled today. Thank you for Viewpoint.